Thank you, Abby. I'm genuinely so excited to be talking to you all about this subject today. Income-based housing is complicated, exciting to me. I sort of like to think of it as the boss level of landlord-tenant law. A lot of people, a lot of attorneys practice some landlord-tenant law, but it is my hope today that I can teach you enough to where you can issue spot important things that you would need to know in cases that involve some sort of income-based housing. And then you would know where to go for the answers to your questions about those things. I do not hope or expect to go through every issue with every type of income-based housing. I would like to give a broad overview. And so I'm sort of assuming that if you've registered for this CLE, you have some basic understanding of Arkansas landlord-tenant law. But if you're new to this area, I would suggest that you go back and watch a CLE that Jason Auer from Legal Aid of Arkansas and I taught last year. It is on the Access to Justice Commission website. I believe it's recorded. So that can give you just some general background to give you some context for some of the things that we'll be talking about today. Bear with me one moment while I share my screen.
I can see it.
Okay, and it's the correct one. It's not the speaker version.
I can see show taskbar display settings in slideshow. So I think this is the.
Okay.
I think this is the speaker version. Maybe display settings.
Is this better?
Yes, that's it.
Okay, great. All right. So my main goals for today are to teach you all how to find out what type of federally subsidized housing you're dealing with when a client comes to you with a case that involves income-based housing of some kind. And, you know, when I get one of these cases, the first thing that I do, I find out, you know, is the rent based on the tenant's income? If so, what kind of income-based housing is it? Then I go and I check the regulations for information about that kind of housing. So we'll talk about the main types of income-based housing. We'll talk about how to identify income-based housing subsidies and common issues that you see across different income-based housing programs. You can think of income-based housing in a few different categories. Most of them are going to be a property or a project where the entire building gets some sort of subsidy from the government in order to make the rent more affordable for the people who live there, for all of the tenants in all of the units. So I would call those project-based, where the money is attached to the property itself. There are other kinds of programs where the subsidy is tenant-based. Some of you may, know what Section 8 vouchers are, or technically they're called housing choice vouchers. And in that sort of program, you would have a low-income tenant who is approved for a voucher, which is something that is funded by the federal government from HUD specifically, sort of filtered down through a local government agency called a housing authority or nonprofit entity. It comes through them and then it goes to the tenant, and the tenant goes and rents an apartment or a house or whatever kind of dwelling they want from a private landlord, and they use the voucher or the subsidy in order to pay the difference between what they can afford and the fair market value that the landlord, would get for the rent, so that the landlord ends up getting the full amount of rent for the unit, but the tenant only pays what they can afford. Okay, most of the programs we're going to talk about today are funded through the U.S. Department of Housing and Urban Development, or HUD. There are some other programs through the USDA that are similar to HUD programs. There's also something called a low-income housing tax credit, which works a little bit differently than most housing subsidies, but there are a lot of common themes across all of these programs. But it's important to keep in mind that for each of these programs, there are going to be federal regulations on how the program is to be run that are tied to, whichever agency provides the funding, right? So if you've got a client who owns a project-based Section 8 building, then you're going to go and look at HUD regulations about project-based Section 8 buildings and the rules that they have to follow. So somebody comes to you and there's some sort of income-based housing involved in the case. How do you actually know what's going on here? Well, there are places that you can go and just look this up. You can look in the lease agreement and you can look at various documents that the parties might have on them. However, I prefer to just go to databases that pull this information from like HUD and the USDA because in my experience, that tends to be a bit more accurate. So I will show you how my favorite one, the National Housing Preservation Database, works. This is a really good database. It's maintained by the Low Income Housing Coalition. It's updated a few times a year. It gets its data from federal agencies. It's free. You do have to register, but it's free once you have your account set up. Okay. Abby, are you able to see the preservation database on your screens?
Yes.
Okay, good. All right, so if I go here, I log in. Okay. So I'm logged in. I go to full data access. Let's say that somebody comes to me with a case from Conway. So I'd go in and look up City of Conway, Arkansas. And this is going to pull up virtually all of the income-based properties in the City of Conway. What it won't show you is if a tenant has some sort of tenant-based subsidy, like a Section 8 voucher, that's not going to show up on here. But it will show you things like public housing, any kind of building that has a subsidy tied to it or a tax credit. And you can hit these arrows and see a little bit more about them. They can tell you, whether the subsidy is still active, what type it is. This will give you a lot of information right here. It'll tell you who owns it, who manages it, sometimes information about, the mortgage. And you can also go to details, and I like to print this page out and keep it in my case file. But so here, I would go and look at the relevant regulations for this kind of project-based Section 8 we're dealing with. Okay? All right, let me get back to my PowerPoint now. Okay. There are some common issues across different federally subsidized or federally funded housing programs. In every case, you should go and check the regulations that, correspond to that property. But there are some themes, right? There are themes when it comes to things like rent, how much the rent is, what the habitability standards are, how evictions are to proceed. Federal law gives tenants and landlords different grounds for eviction. than Arkansas landlord-tenant law. And, you know, the parties have agreed to those standards by participating in these programs. And there are some additional procedural requirements that owners or managers have to go through before they can evict a tenant from most federally subsidized housing. There are some issues where if it's a tenant-based program, like a Section 8 voucher, the tenant can actually be kicked out of the program or have their subsidy terminated. So we're going to talk a little bit about all of these issues. Okay. For HUD programs and most programs, rent covers what you would think it covers, you know, possession. The tenant gets to live in the unit in exchange for the rent, but it almost always also covers utilities and maintenance. So the tenants shouldn't really be charged additional fees for things like routine maintenance in most subsidized housing. And the tenant's income always matters when you're dealing with affordable housing programs. But the programs vary a little bit in how the rent is calculated. There are formulas that are set in the federal regs and other, you know, just internal policies of housing authorities that might give out some of this federal money. So just to take a step back here, as I was saying earlier, there's going to be a government subsidy that comes from a federal agency. And that subsidy pays the difference between the fair market, you know, value rent for the unit and the tenant's portion of the rent. The tax credit program does this a little bit differently, but this is kind of the general rule for most programs. And it's very important to keep in mind that the tenants are only like legally liable for their portion of the rent. The subsidy is the responsibility of whatever agency has agreed to pay that subsidy to the landlord. So just to go through an example, say you've got somebody, Sally has, you know, a Section 8 voucher, and she goes and rents an apartment, and the apartment is like $800 a month. That's the, you know, just the fair market value for the apartment. The local housing authority agrees that that's a good amount that should be charged for an apartment of that kind, of that size. So that's going to be the contract rent, the $800 base rent for the unit. The tenant's portion of the rent is going to be based on her income. And that there are a few different formulas that can be used. The most common ones are going to be like 30% of the tenant's monthly income with some exemptions, or, you know, 10% of their gross income per month. Some programs use like flat rents. That would just be the policy of whatever property you're dealing with or housing authority you're dealing with. But the tenant's portion of the rent is going to be based on their income, right? So then whoever pays the subsidy is going to come in and pay something, you know, a subsidy of some kind. In Section 8, it would be called a HAP, Housing Assistance Payment. And they pay the HAP, and that covers the difference between the contract rent and what the tenant's portion of the rent is. So some issues can come up if there's some sort of dispute or misunderstanding and the HAP is not paid, or it's not paid on time, or it's short or something like that. And the tenant is then threatened or otherwise punished for that. So I would be careful about that because the tenant's not really liable for the subsidy. That's the responsibility of the agency that provides it. The tenant does need to comply and give that agency what it needs to make sure it's the right amount. But the tenant is responsible for the tenant's portion of the rent, not the whole contract rent in most cases. There are habitability standards in virtually all income-based housing. and these are set by federal law. In HUD, we call them housing quality standards, and pretty much all programs require housing to be decent, safe, and sanitary. What that means will vary by program, but generally, it has to be free from pests, it has to be safe, it has to be structurally sound. People have to be protected from the outside elements, the basics that you would come to expect. And the cost of routine maintenance is included within the rent itself. So tenants would not be charged for things that they're not responsible for or that they didn't cause through negligence or something like that. Just to make sure that people understand, it's sort of well known that Arkansas has weak habitability requirements at best. That's changed a little bit within the past year, but even if someone is renting in Arkansas, if they participate in one of these income-based housing programs, the parties have agreed to follow the rules of those programs, including the habitability standards. So that could be an issue that could come up in a case, or it could be an issue between the property and whoever is funding the property, because that would be a condition of their funding that they have to follow. Evictions in income-based housing are a little different from evictions in private housing. In Arkansas, the most common way that you would evict someone is through the unlawful detainer process in circuit court. And that's usually going to start with like a 3-day notice to vacate that, usually gets put on the tenant's door, right? So forget everything you know about that. Not really, but there are a lot of steps that have to happen before you get to that point when you're dealing with federal housing. Okay, so look to the regs once again, and that's where you're going to find out what the grounds are for the eviction and what process the owner or manager has to go through for the eviction. Generally speaking, federally subsidized housing requires good cause for a tenant to be evicted. In private housing, you see evictions for like holdover tenants. If someone's lease expires and they remain in the home, then they can be evicted in Arkansas. That's sort of the default rule, even if the landlord has a bad reason or no reason at all for not renewing the lease, as long as it isn't discriminatory, right? Subsidized housing is different because they are required to renew the lease. For most programs, they're required to renew the lease unless there's good cause not to. And if there's good cause to not renew the lease, there's probably good cause to evict the tenant. So holdover tenants being evicted just because their leases have expired, that really shouldn't be happening in subsidized housing, or you shouldn't be seeing it often. It would normally be like that, maybe, and some other circumstances that gave rise to the good cause, unless you're dealing with Section 8 vouchers, because then you have private landlords, and that program, I think, is a little bit more lenient when it comes to these sorts of things. So good cause, the grounds for eviction, those are going to be defined in the regs. And also there are going to be opportunities for the tenants to be heard and to contest the eviction before anything is ever filed in court. And it's very important to get this right, because if you don't, that could be used as a defense within an unlawful detainer case. It could possibly come up as some sort of counterclaim, some sort of civil rights claim for a denial of due process. So just avoid that and follow the regulations and get it right before you file. What is good cause? What does that mean? What are the grounds to evict a tenant in income-based housing? They're not that strict. but it is stricter than private housing. I'll give you an example. With public housing, you're going to need to have a serious or repeated violations of material terms of the lease. For example, an isolated incident of non-payment of rent or late payment, that is not a serious or repeated lease violation. It is a lease violation, but a relatively minor one. However, chronic, unjustified non-payment of rent would be a serious or repeated lease violation that you could evict someone over, right? If the tenant is over income, the whole reason these programs exist is to provide low-income people with affordable housing. That makes sense. And then there's something called other good cause. And other good cause is pretty broad. It includes a few different things, but these are not exhaustive, right? So serious criminal activity or alcohol abuse, usually it's going to be activity that threatens other tenants or the safety of other people at the complex. That's going to get them out, right? If it later comes out that the tenant is not eligible for the program that they've been accepted into, that could be good cause. If the tenant lied or something of that nature when they applied for the program, or when they go through and they recertify what their income is every year, that could be good cause. In public housing, there's something called a community service requirement that some people have to do, and if they don't do that could be good cause. Or if the housing authority is approved to, do a new version of the lease, and they go through the right process to get that approved, but the tenant won't sign the new version of the lease, that could be good cause under the regulations. So, assuming that there is good cause or some other ground, the tenant would then receive an eviction notice. And the notice has to be fairly specific. It has to tell the tenant what the grounds are and any right to be heard that they have to contest this. And as a best practice, I would not just cite the lease provision that's been violated. I would actually state the facts along with the lease provision, so that the tenant can't argue that they weren't given specific enough notice. Notice periods vary by subsidy, or sometimes they vary based on the reason why they're trying to evict the tenant. Federal law, the CARES Act that came out a year to a couple of years ago now, some of you will remember this because there was an eviction moratorium under the CARES Act. And the eviction moratorium, that one expired quite a long time ago. But one part of the act that remained, and it seems like it's going to remain just indefinitely, is a 30-day notice requirement in evictions based on non-payment of rent when there's some sort of federal funding involved. So if somebody comes to you and they're like, I want to file an unlawful detainer case against someone who's behind on the rent, I would give that person at least 30 days notice if you're dealing with federally subsidized housing, which is pretty different from your standard unlawful detainer case in Arkansas that only requires 3 days notice. Some programs have an opportunity to cure, meaning that, if the tenant violates the lease, they're entitled to get notice in writing of what the violation was, and they're given a reasonable opportunity to go back and fix whatever they did, if it's something that can be fixed before they can be evicted for it. Here's a good chart of notice requirements for different housing programs. I would just go ahead and bookmark or save this if this is an area of law you practice. This was written by the National Housing Law Project. It doesn't have information about the CARES Act 30-day notice requirement, but otherwise I think it's pretty up to date. Most programs provide the tenant with an informal opportunity to be heard before an eviction case is ever filed in court. And what this opportunity will look like is going to vary based on the program. Generally speaking, the tenant will receive at least 10 days to, request an opportunity to be heard informally. And that might be an informal meeting, an informal conference, or an informal hearing. These are all different things. Well, meetings are different from hearings. An informal meeting is pretty much what it sounds like. The tenant would get to meet with the owner or sometimes manager that wants to evict the tenant. And the point of this is that they meet informally and discuss the issue and see if there's any way that they can fix what's going on before any litigation is filed. And it gives the tenant an opportunity to do some informal discovery, right? That's going to be used most of the time if you're dealing with the Section 8 program. But if you're dealing with something like public housing, which tends to be a little bit stricter for procedural requirements, then tenants are actually entitled to something called a grievance hearing. I like to call them informal hearings. Think of, if any of you do like Social Security or some sort of administrative law, it's very similar to this, although often even a little bit less formal. You're going to go before your local housing authority. Sometimes they're also called public housing agencies. And the structure of it is oftentimes like a hearing in court. There's going to be a hearing officer who is oftentimes not a lawyer, but they are supposed to be a neutral third party who did not make the decision to evict the tenant, right? But the parties will plead their cases and the hearing officer will make a decision. And if that decision is that they do have the right to proceed and attempt to evict the tenant, then they can go ahead and file an unlawful detainer case in court. It would not be that the tenant has to appeal that decision to court. It does not work that way in Arkansas. The owner or manager would then have to go and initiate an unlawful detainer case in court, just as a separate phenomenon. There are some red flags that you can look for in income-based housing cases. Landlords can absolutely evict tenants if they don't pay their rent, right? In income-based housing and other kinds of housing. But when you're dealing with income-based housing, if the tenant can't pay their rent, something has gone wrong, right? Whether that was whose fault that is that remains to be seen, right? But if a tenant is being evicted for non-payment of rent, here are some questions that I might have. I would want to know, has the tenant gotten adequate notice? Because they're entitled to 30 days notice under the CARES Act. And even before we had the CARES Act, the federal regulations required a longer period than your standard 3-day notice that a private tenant would get in Arkansas. And if the tenant has been behind on the rent for more than 30 days, then I would want to know, is the rent correct? Like, is it correctly calculated based on what the tenant's income is? Because if they're behind, you would think that maybe their income has gone down. Maybe. So these are things that I would want to look into. An isolated incident of non-payment is usually not going to be good cause to evict someone in subsidized housing. Chronic non-payment without any reasonable explanation, that'll be fine. That would be a serious lease violation. So I would also want to know if the amount of rent that the tenant allegedly owes is really their portion of the rent, or if the housing assistance payment is being included in that. Because sometimes you'll see a complaint that would say, tenant didn't pay her rent in September. The rent is $800 a month, so she's a few months behind now. But it doesn't say anything about the fact that her portion of the rent is actually $200, while the owner has continued to receive and has accepted housing assistance payments for, the $600 difference between those amounts this whole time. When you're dealing with programs where you have a tenant-based subsidy, like a Section 8 voucher, tenants can be removed from these programs if they don't follow the rules of these programs. And there's a way to do that set out in the regulations. And housing authorities, which are usually going to be government agencies or nonprofits that handle public housing and Section 8 vouchers. Sometimes they'll handle other programs as well, but they're the ones who are going to be going through the termination process. And sometimes if the tenant does something, like if they're evicted from a Section 8 building, they're actually required to try to cut the tenant's voucher off or terminate them from the program. And so they don't have discretion in all cases. If there's something else that happened, in some cases they have discretion, in some cases they don't. But in every case, the voucher holder has to get notice and the right process has to be followed. So for a Section 8 voucher, the tenant is going to be entitled to an informal or grievance hearing, similar to a public housing tenant who's getting evicted. So same deal, there's going to be a hearing officer who is supposed to be a neutral third party. They're allowed to present evidence on their behalf. They're entitled to evidence that the housing authority is relying on to make its decision, sort of like informal discovery. But there's no court action that's required to cut off someone's voucher or other type of subsidy. It is only an informal hearing. At least in Arkansas, that's the case. Okay, so that was probably a lot of information to process, but here's some resources that you might want to turn to if you come into one of these cases. Here's the National Housing Preservation Database that I showed you guys earlier. The National Low-Income Housing Coalition, they have a database. I'll show it to you real quick. I've got some time. And this goes over multifamily properties that are subject to the CARES Act. And sort of ignore this bit about the eviction moratorium. That's about the moratorium that was in place for a while. But the CARES Act notice requirement is still in place. And you can look up places with 4 or more properties that are subject to it in this database. In my experience, it's pretty accurate. I have seen some questionable things just because there wasn't enough information. So here you could go and see that this property here has some kind of income-based subsidy from HUD, the USDA, or the IRS, which would be a low-income housing tax credit. And you can also see some information about the mortgages here that's not really relevant to our discussion today. Okay. I rely on the National Housing Law Project all of the time for research. They're a good national advocacy group that works on housing issues. Sorry. And they have a lot of really good materials on their website. There's something called the Green Book. It is a physical book that is probably in every legal aid office across the country that talks all about tenants' rights and responsibilities in HUD and other federally funded housing. I won't look at the Green Book right now, but there is a digital version that you can access online right here. You can also order a hard copy through this website. You can watch lots of webinars on housing issues, and I would get on their email list if this is an area of law that you practice often. And also, if you're dealing with a tax credit property, in Arkansas, those are run through the Arkansas Development Finance Authority, and their compliance manual is online. Okay. If you have any questions, I'm also a resource. You feel free to reach out to me about any of these things if you're not able to figure out the answers on your own. And Abby, I know we've got quite a bit of time left, but I was wondering, can we go ahead and address any questions that people might have?
Yes, we have one question in right now. This was asked back when you had the slide up about good cause for eviction. And they asked, how would you deal with an income disparity between reporting systems and what the tenant claims and can support by their documentation? And I don't know if maybe that person wants to claim the question and elaborate.
I have some thoughts, but did anybody want to expand on the question?
Whoever asked that question, if you'd like to add some more to it, just raise your hand and I'll unmute you.
I think that I do understand the question because a lot of subsidized places have access to like big national databases or that pull information about the tenant's income and like any government benefits that they might receive, Social Security, child support payments, things like that. And so if there's a discrepancy between what these systems are saying the tenant is making and what the tenant is saying the tenant is making, you should probably talk to whoever provides your subsidy about what they want you to do there. How I would handle it is probably a little bit different because in my line of work, I work at a legal aid office and I typically represent tenants who are facing issues in government subsidized housing. So, I think that issue would be debatable if it ever went to court. The tenant would get a chance to put on evidence about what their income is. But I would, from the perspective of the property, I would speak to whatever agency gives you your subsidy about what they want you to do there.
We've got a question from Christopher in the chat, and he says, can landlords discriminate as to the acceptance of subsidy vouchers? By this, I mean only allotting certain apartments or subsidized rentals.
Yes, they can. So some states have what's called source of income discrimination laws, where landlords are not allowed to turn people down based on the source of their income, like if it's going to be through a Section 8 voucher or through a Social Security or disability payment. But Arkansas does not have a source of income discrimination law. So many landlords, for a variety of reasons, choose not to accept people that receive Section 8 vouchers. Which is unfortunate because it's unfortunate for people who receive vouchers because it limits the housing opportunities that are available to them in, sort of like good neighborhoods that might give them a lot of upward mobility. But landlords certainly have the legal right to do that. Yes.
John Cortez asks, is there something like a registry for people who have been evicted or owe back rent that allows other housing agencies to see the person's history? And if so, is there something the tenant can do to get removed from that registry?
Yes, there is a registry that shows debt owed to public housing agencies. It shows debt owed to, HUD owners, and you would think that the person could file bankruptcy in order to get cleared. That sort of remains to be seen how that would work in Arkansas. But I think that's something that Doug and I have discussed offline. However, they could pay the debt, right? That would be an option. Or they could potentially, have the debt. Sometimes the debt will be taken out of their tax refunds. The state will, it's sort of like if you owed money to a state agency like DHS or something, if you owe money to a housing authority, they can, in Arkansas, intercept your tax refunds in order to recover the debt.
And someone wants to know what that registry is.
I believe it's called, I don't want to tell you the wrong name. Am I still sharing my screen?
Yes.
Okay, one second. I believe it's the HUD EIV system, which stands for the Enterprise Income Verification System. It includes employment and income information, and I will send some information about that system in the chat right now.
Calvin Beasley is asking, how would someone in low-income housing go about reporting habitability issues if the landlord isn't responding to the request to fix that issue?
So they have a few different options. They could try to go through their local code enforcement at the city level. Some cities are more aggressive about this than others. Some cities might not really have code enforcement at all, but they can also report the issue to the government agency that funds the complex. And in my experience, that's a very effective way to put pressure on the owner or manager to fix the issue, because it could be a problem with, their compliance with whatever funding they're getting. This assumes that, maintenance isn't willing to just fix it voluntarily. And in theory, they could take them to court if it comes to that.
Another question here. After being legally evicted for things like people who are not named on the lease living in the rental, how long does it usually take before they're able to use the assistance programs again?
Different programs are going to have different rules about that. I have heard some programs have a 5-year look back period that they look to, but I think that they have some discretion about how long they consider things like that.
If anyone has any more questions, we do have a little bit more time. And we did get a clarification from our first person who asked a question, if we want to go back to that one. So just as a reminder, they said, how would you deal with an income disparity between reporting systems and what the tenant claims and can support by their documentation? He says, to clarify, or they say, To clarify, landlords use these systems and then claim they cannot give it to the tenant to check its accuracy, then try to evict them. And because they do not give the tenant the information, they cannot get the systems updated.
Well, if I was representing a tenant, I would raise that issue as a defense within the court action to evict the tenant. I mean, generally, if you're going to report on somebody's credit, it's my understanding you have to give them the information that you're relying on. And if they're in court, you know, they would have that person would have the burden to put that evidence on and prove it.
Okay, we've got another question here from Natasha Graff. Are there state mandated habitability standards for rental property? If so, where would you find them?
Yes, Arkansas passed a law within the past year that creates something like an implied warranty of habitability statewide. If you'll bear with me one moment, I can get you the statute. But unlike most states, it's sort of lacking when it comes to enforcement, right? So it has certain standards of, you know, all landlords have to do these things and provide these conditions, but if they don't, the tenant's remedy is to move out of the unit and break the lease without penalty. So there isn't really much enforcement there. But if you'll bear with me, I will look that up and give you guys the citation.
In the meantime, just a reminder for everyone that the CLE forms will be emailed to everyone who attended after this, and there's an email address at the top of the form where you can return those, and they can be e-signed. You don't have to print them out and sign them physically. Try to get those back to me by January 26th, which is Wednesday of next week. That's not a hard deadline, but I'd like to have them back by then. A comment from Doug Cortez, who's also at CALS, for those who can't see the chat, regarding the EIV registry and bankruptcy. The negative information will stay on the registry, but the registry will show a bankruptcy was filed.
Good, thank you, Doug. Okay, I'll put a copy of the bill for that habitability law into the chat, and I'll supplement this with a better site later. Abby, will we be able to send out materials to the attendees afterwards?
Yes, we can. Initially, I was going to just send the PowerPoint slides to people who requested it, but we can also just do like one blast as well.
Sounds good. Okay. All right. Any other questions?
I don't see any other questions. So I guess we're going to wrap up at this point. Everybody knows what to do with their CLE forms once they get them. And if not, just email me. Thank you so much, Kendall. It was great to have you. I hope everybody got
having me
out of this. And everybody enjoy the rest of your Friday. Have a good weekend.